Welcome to Reducing Risk, a series of podcasts from Medical Protection, created specifically for doctors in Aotearoa, New Zealand. Reducing Risk looks at key medico-legal issues in our jurisdiction and provides helpful advice and guidance on how to manage those risks. This current series focuses on privacy. And today, our topic is how to respond to the police and other agency requests for patient notes. My name is Dr. Sam King and I'm a medico-legal consultant with Medical Protection. I'm joined today by two of my colleagues, Dr. Lucy Gibbard and Dr. Tim Cookson. They are GPs by background, as am I. And we are also joined today by Mr. Joe Fitzgerald, who's a lawyer with Watt & Carney, our panel law firm. And Joe specialises in privacy issues. So welcome, everybody.
Thanks, Sam.
Hi, Sam.
Thanks, Sam.
So let's think of a scenario first up. It's 4 p.m. on a Monday afternoon, and we all know how busy Mondays can be. And a police officer is at reception asking to speak with you about one of your patients. They want the patient's clinical notes and they say it's urgent. What do you do? Lucy, what sort of things do you think you might want to ask the police officer?
Yeah, and I think this scenario is not uncommon. There's a lot of things you need to ask. I think one of the things to think about at the start is, do I know what to say and what to ask? And so maybe every practice should have a privacy officer, and maybe that would be a good person to have involved in that conversation. I think one of the risks in this situation is having a relatively new receptionist taking that request and taking it upon themselves to make those decisions. So I think it needs to be clear to you and all your staff that if you get this kind of request, the privacy officer is probably a good person to involve. And then I think you need to think about, it's obviously the police. There may be a very reasonable reason why they need that information. It may be in your patient's best interest to release it, but actually you really want to make a good decision about that because the patient may not want that information released to the police. So first of all, I'd say, what exactly do you want? What part of the notes and why do you want it? Where's the risk that stops me being able to ask the patient for permission to do this? Have you got a legal basis for your request? And in that situation, you're asking the police officer whether actually there's some piece of legislation or they have some documents that mean that you have to release the information. Or maybe they've got the patient's consent. Sometimes in some situations where the patient's been a victim of a crime, they may well have the patient's consent, and it would be helpful to see that. And then it's also helpful to ask when do they need it, because urgent is different sometimes. So, and in general with privacy requests, you would generally have 20 days. But if there is urgency, obviously there may be reasons why you need to provide that sooner. So it would be nice to know what your timeframes are. So I think that's probably where I'd start.
So in primary care or in a private clinic, there probably is a privacy officer and they will come to reception. But what happens in the hospital? Tim, do you know what happens in the hospital if the police come calling and the process that might take place there?
Well, again, hospitals have got legal advisors and I imagine they've got privacy people as well. So I think a clinician in that situation would want to get immediate advice from their legal advisors as to what they should do. And it may well be that the next conversation occurs between the police and the legal advisor, and then the legal advisor will go back to the doctor and say, okay, look, we've been through this and this is the information that is reasonable to release with the consent of the organisation, because of course the doctor is acting in that position on behalf of the organisation. They're not acting as an individual.
No, that's great. And I think I really like the fact that you've got to think about what you need to ask, and it's a way of slowing things down, isn't it? If you know what to ask, then you can temporise, as opposed to, of course, I'm just going to give you everything you ask for, officer. So that's really great advice.
We're kind of conditioned to comply, aren't we?
We are.
With someone that we perceive in a position of authority like the police. So, yeah, you're right. You need to resist that initial kind of feeling, yes, I must do it.
I must do it.
And think about what you're doing.
But you also don't want to be too obstructive either. You've got to find that nice fine line, don't you? Because actually sometimes it's actually there's a reason and your patient might be at risk, and actually you don't want to be obstructive. I think you want to be professional and polite and calm and ask the right questions, but that not obstructive, not overly giving the information away without thinking.
So
basically.
if your only response to the police officer is put it in writing and I'll respond in 20 working days, you don't think that's going to cut it?
I don't think that will cut it, Tim. No.
Right.
If I could perhaps add one thing there, I suspect something that has perked up people's interest, particularly in smaller practices, is either, oh gosh, I think we had a privacy officer, but I can't remember who it is, or whoever the privacy officer is hasn't actually had to sort of engage with those skills quite a while, because I know that whoever is the privacy officer, particularly in a smaller organisation, probably wears a number of hats. You're probably doing other things as well. You have other obligations. So if that has been your reaction, the Office of the Privacy Commissioner has some wonderful resources for if you do have a privacy officer, but they want to scrub up on their skills, or you actually realise maybe you had someone who was your privacy officer and they left. Certainly having a look on the OPC's website and having a look through those resources is a really good way to upskill people, so that when this question does come through to them, they are prepared and they know the kinds of things that they should be asking.
No, that's great. Thank you. I think, for example, thinking about hospitals, in ED, in the middle of the night, it wouldn't be uncommon for a police officer to come and say, we need some information about a particular patient. And in that moment, I think the clinician does need to have some tools, really, to know what to say, how to deal with these sorts of situations. So I think for all clinicians, it's a great idea. Get on the Privacy Commissioner's website and upskill.
And the other thing is, it's always better to have a think and maybe get advice. So ringing MPS, or your indemnifier before you release anything. It's always hard to take something back. So, taking that time to think before you give it out is the best thing.
And if it's in the middle of the night, I'll give you Tim's cell phone number is. Very happy to give you advice.
Left at the other room and end of the house, of course.
So let's think of a scenario. You've got a 68-year-old patient with early dementia and he's gone missing. So the police are looking for them. The patient was last noted at the local supermarket looking very upset and had gotten into their car and driven off. The patient, in fact, had not meant to be driving. So what do we think about in that situation? I mean, Lucy, you mentioned before about this, thinking about the urgency, not being obstructive and not taking the 20 days. The police quote Privacy Principle 11E. Tim, would you mind just talking to our members about what 11E is and whether this, in fact, might apply?
So 11E relates to release of the information, again, without consent, for some specific reasons, and that the disclosure of that information is necessary, one, to avoid prejudice to the maintenance of the law by any public sector agency, and including prevention, etc., and punishment of a whole lot of offences. It could be for the enforcement of a law that imposes some kind of pecuniary penalty or fine. It could be relating to court proceedings, or it could be, more importantly or more likely for us, that the disclosure of the information is necessary to prevent or lessen a serious threat to either public health or public safety, or the life and health of the individual concerned or another individual. And that's probably the key bit that most of us would be concerned about.
Right,
And
so
clearly in this situation, it does look like there could be a risk to the elderly lady who's driving without the apparent ability to do so.
So that's Privacy Principle 11E and F, I think you were just
That is
talking
F,
about.
indeed. Yep.
And that F1 used to have the word imminent in it. So it used to be that to prevent or lessen an imminent serious threat to public health or safety or life or health. And they've taken the word imminent out, which actually makes it a bit easier for us, because it's always hard to know how long it's going to take for that person to have an accident on the road, and is that imminent? So the word imminent's not there now, so it makes it a little bit easier for us to use that provision.
So if we're thinking about that provision, Joe, why would they have taken the word imminent out? And is it something that we still need to consider?
Yeah, great point. So lawyers really love this kind of thing. Parliament doesn't withdraw words without a basis to, right? They've done that very intentionally. They've done it because they're saying this is not a box you need to tick anymore. What I would say is that when you are providing information under this heading, you're not compelled to, you're not forced to. You are choosing to provide it, and it's just something you always want to consider when you are providing information is what is necessary for the purpose you're providing it for. And imminency does sort of have something to do with that, doesn't it? It certainly relates to how much you might provide, the urgency with which you might provide it, the extent to which you consider what other information might be relevant. So while they've taken the word imminent out, I think it's still something you want to be considering vis-a-vis what it is you're actually handing over. I mean, in this situation, it might be that if this person is believed to be missing at this point in time, that you do provide more comprehensive information. The threat is real, and they're probably going to need to do a more comprehensive search to find this person in the short term. So, look, it's not a factor that's in there anymore. Parliament took it out very explicitly, but maybe something that we still want to have in the back of our minds. Certainly. The main factors remain, the severity and the likelihood of the harm manifesting. Those are the two things you really want to be thinking about, and I'm sure they're the two things that people's minds would kind of naturally think about. Anyway.
And does the question of how much information to provide to the police come into this? So, do the police need to know that she's had recurrent urinary tract infections, for example? Or is that going to be the issue, or is it going to be something more significant?
Absolutely, Tim. You're quite right. There's, as I may have alluded to, there's this general concept of data minimization, which kind of perforates through all our privacy legislation. Only use or disclose or provide as much information as you need for the actual purpose. So this might require actually having a bit of back and forth with the police in this case if they have approached you. They've provided a bit of background. What do they need to know from you? Why do they need to know it? This serves sort of a dual function, doesn't it? This person obviously needs some assistance. You want to ensure the information you're providing is useful to them. You want to ensure that they're getting what they need, but you also want to make sure that you're not providing them with too much. That is where you potentially run into concerns further down the line, isn't it? I mean, if you were just to print off their patient file and just hand it over, you could see why that person in the fullness of time might not be happy. So absolutely, you want to give close consideration to what you're providing. And to tie it back into the wording of the statute, these exceptions do start with, you don't need to obtain consent if you believe on reasonable grounds. So this is really about, it's not about you coming to the perfect decision necessarily, but it's about, satisfying yourself that the police need this information to achieve this purpose. So it's all about, what do you, in making this decision, believe, and what are your bases for thinking that? So exploring with the police, what it is they need, why they need it, and what they're going to do with it is a useful thing for you to do.
Thanks for that, Joe. So this is under Rule 11, it's not a compulsion. They're not compelling you to release the information. Is that right?
That's exactly right. So if the police were to come to you with, I think earlier we mentioned production orders, search warrants, these sorts of things, in those circumstances, they have a legal basis to compel you to hand over the information. You should still, engage with them in the way that Lucy's described and ask some questions. But when they haven't come armed with those documents, you are exercising your discretion to provide the information. And what Rule 11 does is allow you to do that in those circumstances. So this is a case of the police coming to you, and you can see in a situation like this, might be they've received this information, they're acting on it very quickly, and they don't have a production order to hand. So when that happens, if you are minded to provide the information, you're not volunteering it per se, but you are providing it without being compelled to. You're providing it because one of these bases apply.
So you mentioned a production order. Would you mind just telling our listeners what is a production order?
Yeah, it's fair enough. I can't imagine many of us have come across them in our personal lives. Look, the production order is an instrument under the Search and Surveillance Act. It's effectively the document police use when they want to compel individuals, agencies to hand over documentation. You can think of it as a kind of search warrant, but instead of the police coming and investigating a premises, they are requiring you to hand things over to them. So production orders are very standard forms. At the risk of saying something that sounds a little bit silly, you'll know one when you see one, because it will be very clear what it is. If the police do ever come along with a production order, you should ask them to explain it. They have to do that. They have to actually explain why it is, or what it is they're asking from you, and why it is this document allows them to request it. If the police do arrive with a production order, there's carve-outs from the Privacy Act for those sorts of things. So long as you are providing the information that is requested in the production order and sort of no more, you're not going to find yourself in any trouble.
Yeah, and I think that's something we often talk to members about, is that when you provide information using your discretion under Rule 11, later on you can envisage a patient being upset that information was released, and they may make a complaint and say, well, you shouldn't have used your discretion, there wasn't enough risk and that was the wrong thing to do. If you release it because you've been given a production order by the police, well, actually you have to release it then, so it wasn't your choice, and really the patient can't come back at you and say you shouldn't have done that because you had to. So I think in a lot of situations, especially where there's not a real urgency, then actually if a police come along and say, would you like to use your Rule 11 discretion to release this to me, it's a reasonable thing to say, well, would you like to give me a production order? Because it's actually not that hard for the police to get a production order. They don't have to go to court. And actually, if they really need that information, they should be able to get a production order. And then it's easy because you have to give it.
And if I understand rightly, a production order is for specific documents, isn't it? They can't just request everything that might relate to such and such topic. They have to specify the information that they're looking for.
Absolutely. If the police arrive at your doorstep with a vague production order, where the ambit of it is not entirely clear, ask some questions. And ideally, it's probably a situation in which you want to seek some advice from the likes of MPS, because it's that is poor form. We do see them out in the wild rarely. Normally they're quite specific about what it is they require, because the police want the information. The easiest way to do that is to be very specific about what you want. But yeah, you're quite right. If you do find yourself holding a production order and the sort of the scope of what is required is a little bit fuzzy around the outside, ask some questions and seek some advice on it.
And certainly we've had that experience at MPS where the doctor is concerned, never seen one before, really uncertain about it, didn't want to feel compelled to do something that they really weren't compelled to do, have sent the production order through to us. If we've got any concerns, we've asked for advice from one of the team at Wellington Kearney. So, and that can happen very quickly. It's not a long procedure.
That's great. So in the situation where you've got a patient who's gone missing and there are safety concerns for them, it would be reasonable for clinicians to say, yes, I'm going to provide this information in order for the police to be able to hopefully find your patient. But what about when there's been a death in the community and the police come calling and they want health information? Should we give the information as with the first situation? Lucy, what do you think about that?
Yeah, this is such a common situation as well, where somebody's been found dead and the police want to know what's been happening. And often the first thing you want to do is find out why the police are asking for the information. Are they acting for the coroner? Because in a lot of situations, the police will be acting for the coroner and will be requesting that information on behalf of the coroner, which is different from if they're actually asking as the police, and in which case it may be because they've got concerns about a criminal situation. So I think first of all you say, are you acting for the coroner? Is this a police matter? What information do you need and why? Am I under investigation? Might be a good question to ask. Have any concerns been raised about me? I think that's probably pretty rare, but it does happen. And then go from there, basically.
That's great advice. So a slightly different scenario is the police are requesting health information about a patient who they think has committed a crime. Tim, would your response be any different?
I think the bar is certainly significantly higher here than the case we had before. So I guess one of the first things to find out from the police is do they think there is a significant risk to the public or to the individual concerned for harm, or are they just investigating an alleged crime, or is there a possibility that they're trying to prevent a future crime that they think might be imminent? So all of those things might come into your decision making about whether to release information. And then it's very much the same. What information do they want? Why do they want it? Is there consent? That's going to be pretty unlikely in this circumstance, but worthwhile confirming. And then again, think about asking for a production order rather than providing information on a discretionary basis. Because remember, if you do that, then the individual concerned is going to lose trust not just in you as an individual, but they're going to lose trust in the whole of the medical profession. And so, you've basically ruined the relationship that this person might have in the future. And, if it turned out that they weren't actually guilty of any crime and nothing had gone wrong, there's no reason for it, but you've breached their privacy, that's a biggie. And, I think you've got to think really carefully about that. So, yep, absolutely seeking advice in this situation, I think, would be a key.
Thanks for that, Tim. So another question for you, Jo. If the police haven't come knocking, but I'm aware that my patient is, say, diverting medication, can I go to the police without them coming with a request?
Yeah, it's a really good question, and it's a tricky one. We've already talked about sort of the bases on which you can disclose information, and again we're coming back to those Rule 11 considerations. What the OPC is suggesting on its own website is, if you're concerned about the perpetration of a crime or a serious risk of harm, you can volunteer information. I think you'd want to be a bit more granular about it than that. Certainly, if you think there's a serious threat to the life or health of an individual, and having considered it, you think the best way to deal with that is by going to the police. That is a perfectly sensible thing to do. I suppose in the circumstances, the question you want to be asking yourself is, if the reason I'm doing this is to mitigate a serious threat, are the police the right people to go to? Maybe that they are, but there might be other individuals you've been dealing with. Whether you can go to them in instances where there's not a serious threat comes down, in my mind. I'd be interested in others' views who have dealt with this practically. But is this necessary for the prevention of an offence? By doing this, are you either going to help the police or help an offence be prevented from occurring, or are you going to increase the detection of it or allow for the detection of it? Again, it's really interesting hearing Lucy and Tim talk about the clinical considerations here, because you are having to weigh up the decision to do this. There's reasonable grounds to do it for the detection or prevention of a crime against what the impact is actually going to be on your relationship with your client, with your patient in these circumstances. So look, you can, but it's something you'd certainly want to consider very carefully. And certainly if you're in a situation where you're not doing it because there's a sort of a imminent threat, a serious risk of harm, are probably something you want to take some advice on or speak to some colleagues about.
So coming back to the earlier example that you gave, Sam, where the police were investigating a potential crime, if you had the scenario where you knew that this particular patient had a psychotic illness, and though he'd been well controlled in recent times, you happen to know that he hadn't picked up a script for quite some time, then you might think, actually, this guy's really unpredictable. And this is a situation where, yes, I'd certainly want to kick in and provide enough information so that the police knew that there were some real risks around his behaviour and what he or she might do.
It's interesting with these scenarios. I remember one case where we had a police request for an after-hours centre. They wanted to know any patients who had come in the last 48 hours with a particular injury, because they were investigating a very serious crime. But clearly there were several patients who had come in with that injury over the 48 hours, and clearly not all of them had committed the crime. And then you've got that whole risk of, well, you're actually clearly going to be releasing health information of people who weren't involved in the crime, in order for the police to narrow down their search. And then how serious is the crime that actually that's a risk, or that was a, I remember that was a very tricky, do you remember that one, Tim?
No.
It was, where it was a very tricky situation as to how can you narrow the release and still try and help the police as far as helping them identify someone who maybe. And I think we went back to them and said, can you give us more information about the person you're looking for, and then we don't have to release all these people's information. It was an interesting situation.
So if it doesn't meet the high threshold of a serious threat to an individual, we could use the maintenance of the law. Is that right?
Yeah.
Yeah, the prevention, investigation or detection of a crime would apply in these situations. But I think the approach that Lucy just described is absolutely right. Do what you can to narrow down the disclosure that's necessary. I mean, keep in mind these things need to move quickly because the police want to get this person. But also to the extent that isn't in writing, document it. Right, because further down the line, when questions are asked, you want to be able to show, well, we didn't just hand this stuff over. We, best efforts to establish that we believed on reasonable grounds that this was necessary. A really great way to demonstrate that you believed on reasonable grounds is that we pushed back until there was nothing else we thought we could do but disclose the information. That's definitely the way to handle it.
I think the other thing with that diverting medication thing is whether or not you're thinking, should I talk to MedSafe? Should I talk, are there other avenues that can mitigate the risk, which doesn't include me telling the police about these people's personal information, and raising concerns with MedSafe might be another, or Medicines Control is what I meant, might be another way of actually dealing with a patient that you think might be diverting. I think we also have had numerous cases, in fact, where the patient has forged a script or forged a document, and clearly that's a crime, and the doctors ring up and say, have I got an obligation to tell the police that the patient has forged scripts? And from my understanding, there isn't an obligation to tell the police that they've forged scripts. There isn't an obligation to report crime in New Zealand, but actually it's a serious consideration, because are they going to carry on doing that with another doctor? And is there a risk to themselves or others if they're obtaining medication that they shouldn't be? So we generally kind of talk that through with the member about whether or not they think that's a reasonable thing to do. But I think if you do release that in good faith, so I think that's what we often talk to them about. You can't do it in a malicious or nefarious kind of way. But if in good faith you believe that patient has committed fraud, there's a risk of harm, I think that actually you're unlikely to be criticised if you reported that to the police.
And at the risk of sounding like a broken record here, that's absolutely right. The coming up with reasons supporting that after the fact, we have loads of Human Rights Review Tribunal authority to the fact that evidence isn't really worth anything. It's got to be what you thought and the reasonable grounds you had at the time. What was your good faith based on at that moment? So as Lucy says, if you're doing it in good faith, you'll probably going to be okay, but make sure you've documented what that was based on. I mean, it's for two reasons why. One, the jurisdiction, the jurisprudence we have shows that we need that contemporaneous evidence, but the other thing is memories are fallible. You might not be asked about this for a very long time, so make sure you've got something you can refer back to.
And just expanding on circumstances where it might be reasonable to report for example, to the police. There's a very specific one under the new Firearms Act, which says that if you've got a patient and you know that they have a firearms license, and then for some reason an illness occurs, for example, a psychotic illness or a major depression, then there are protections under the Act for reporting to the police the changed circumstances that might have altered the risks for that person holding a firearm.
That's
Interestingly,
great.
they haven't actually said that you have to report it. You've
You
got
must
an
consider.
obligation to consider, which again gives you an obligation to document that you've considered. So actually, that documentation thing becomes very important there, because you have to show that you've considered whether or not you're going to report, and as you say, protected if you do.
That's great. Shall we move on to other agencies that request health information, and the Ministry of Social Development sometimes send practices requests. And here's an example of one. And in the letter from MSD, it would say, take notice that under Section 11 of the Social Security Act 1964, I require you to furnish copies of the following documents and or information in your custody or control. And then they will say, patient enrolment forms for Mr. Smith. You must supply the above information and or documents to the following office of the Ministry of Social Development and without charge. And then you get the address. You must supply the information or documents within 10 working days after the date of this notice is given to you. If this notice came to you by post, you are deemed to have received it on the 4th day after it was posted. That's clearly in olden days, because
I was going to say,
it's
it's
probably more like
hopeful, isn't it?
2 weeks now. And if you refuse or fail without reasonable excuse to comply with this notice, or in purported compliance with it, knowingly or recklessly furnish any information which is false or misleading in a material particular, you commit an offence and are liable on summary and conviction to a fine of not exceeding $2,000. And on it goes. So, Jo, this sort of letter sounds quite threatening. How should clinicians respond?
Yeah, it's charming, isn't it? I note the section regarding the fine is also in bold, which is just lovely. Look, this is a legitimate request. The Privacy Act and the Health Information Privacy Code, which we talk about a lot, are what we call, in some circles, subservient legislation. So if there's another piece of legislation which conflicts, and Section 24, for those of you who are very interested, is the section of the Privacy Act that sort of manufactures this, but if they conflict, the other legislation takes precedent. So here, the Social Security Act, Section 11, as is in the letter, provides MSD with a power to request information, and the reason for this, the purpose for this, is so they're able to investigate various frauds. So look, this request is legitimate. You do have to comply with it. The Privacy Act's very clear that you can't breach any of the obligations, any of the privacy principles by doing so. But it's one of those things, you do have time, and you should also take the time to ask questions if you have them, and particularly, it's something like patient enrolment forms, might have information that they don't necessarily need on there. If you need to clarify, what is it you actually require from me, and you've asked for this particular document, but the people at MSD aren't, they can't see into your systems. They don't necessarily know what's there. They don't know what those documents might contain. And if you have concerns about, for example, sharing too much information, you should feel free to go back and ask questions. I mean, it doesn't change the fact that you will have to comply with it, but it's not to say that it's an entirely one-way street. We've definitely dealt with cases where we've received exactly this request and had a relatively good dialogue with MSD about what the response should consist of.
So what would the purpose of the request be? I mean, they're asking for the enrolment forms. Why the enrolment forms?
So to my knowledge, that would be to establish where someone is living, or where someone what their address is at the time, information that they can feed back into their fraud team to determine things like benefit fraud and that kind of carry on. So that's exactly the kind of question, Sam, that you'd want to be asking them, really, because if what they want to know is where does this person tell you they live, presumably you can establish that by providing them with relatively limited documentation.
That would be true. And I think for a lot of practices, the enrolment forms do have health information, don't they?
Absolutely, yeah.
And that's not something that we want to be passing on to the agency.
Although if they've written patient enrolment form on what they're requesting, and you without thinking give it to them, you are actually going to be protected in that they've asked for it under a legitimate section, and that actually you can do that, but it's
absolutely
it's
you're
a finesse.
fine,
Yeah,
right?
you're
It's
fine.
it's more about avoiding the perception of an issue going forward, right? Like as a lawyer, I probably shouldn't deviate from the letter of the law, but look, you're not going to get in trouble, strictly speaking, for simply providing what they ask.
But I do think that, we are not lawyers, and actually a lot of what we care about is actually the relationship we have with the patients. And that's often where we really struggle with these requests, is because actually we know the patients. We don't want to damage our relationship with them. So that's often why we're being careful, is because we actually have a beyond legal obligation to them.
Yeah, and if you've released information, even though there's a legal entitlement for you to release it, but it's actually information that wasn't required by the agency, then your patient could quite reasonably say, well, look, sure, I understand you had to release some of that information, but why did you have to tell them about such and such?
Exactly.
Absolutely. And I would say, I think I mentioned before, we have found MSD relatively receptive to these conversations. They're happy to talk about these things. So do feel like you can ask for some clarification, particularly if you have concerns about the scope of what they're asking you for.
Often in those request letters, they might say something along the lines of, I would appreciate if you would treat this matter in confidence and send your response directly to me at the address provided below. So does that mean we cannot tell our patients about the request?
Look, it's certainly not something which we would consider to be binding. It's not contained within Section 11. It's not something which MSD can enforce on you. I suppose there's sort of the question of, can you tell your patients and should you tell your patients? They're two very different things. What MSD is asking you for here is confidentiality, and at the very least, you might want to explore why they feel that's necessary. Presumably that's going to inform your decision around whether you feel you have a basis to withhold that information, and if you do choose to do so going forward. So look, no, you can tell your patients. I suppose what you probably want to get a handle on is why MSD have asked that this be kept in confidence, and then you really need to make that decision for yourself.
That's great, thank you. Another agency that commonly requests information is Oranga Tamariki, or as we know it, OT. Joe, they often quote legislation in their letters as the legal basis for their request. Would you mind explaining what that legislation is and how it applies to clinicians, and whether we really ought to be getting parental or guardian consent?
Yeah, of course. So look, not an entirely dissimilar situation to the one we just talked about regarding MSD. Again, we're talking about a legislative power in the form of the Oranga Tamariki Act, and in particular Section 66, which empowers the chief executive, a care or protection coordinator, or a constable to compel an agency to provide information that may relate to or affect the safety or well-being of a child or young person. And then it goes on to provide situations when the information is required. So if it's required to determine whether a child or young person is in need of care or protection under Section 17, or is required for the purposes of any proceedings under this Act. So look, it's a very similar situation. We have an agency here which is using a statutory power to compel the provision of information. Again, if you are simply acting on, this request, that you can't get in trouble for breaching any of the conditions under the Privacy Act. I would say when you receive requests like this, that sort of protection, that veil you're covering yourself with to say, I can't get in trouble for breaching the Privacy Act for doing so, only applies to the extent that you're providing information in response to the request. So make sure you're clear about what it is they ask. I mean, the MSD example we just talked through was very clear about what they wanted. So make sure that you're clear with them about what it is that you are required to provide in response. And in terms of whether parental or guidance consent should be sought, the statutory power enables OT to request this directly from you without their consent. So look, it's something where you need to consider very closely, what information you're providing to them, and then I'd be interested in other views. But the question as to whether you should be informing parents or guardians is going to be context specific. I mean, in most cases, I can only imagine, I'm not a practitioner myself, but if there's concerns about whether young people need protection, I imagine the context is going to be absolutely critical as to whether you're revealing that information or going any further.
So, Tim, in your experience, would you say that it is better to give a courtesy call to the parent to say, Oranga Tamariki has made this request, and I'm just letting you know that we have to provide this information?
That certainly avoids the perception on the part of the parent that you've kind of gone behind their back and provided information, and they may think, learning that you provided that information, that you just kind of volunteered it. Whereas if you make it clear in the call, look, I have an obligation to provide this information. It's not what I've chosen to do, but I have no choice, and I'm just letting you know so that there's no surprises. So I think it's a good thing to do.
I think you do need to think about the welfare of the children with doing that, though. If we're concerned that the parents might uplift the children and spirit them away when they realise that Oranga Tamariki are looking into their case. So I think we need to think about that. And yeah, I do think that if you can, it's nice to be able to maintain the therapeutic relationship by being honest. I also think sometimes these are difficult because it's whether they've asked for the child's information or the parent's information. And often the parents can understand that their children's information is being requested. They're often less happy about their own health conditions being released to Oranga Tamariki.
So, Joe, is it if the OT have asked for the parent's health information, does that same legislation compel the clinician to release it?
Yeah, it's an interesting question, and it's interesting because of the nature of the legislation. So what it says is any information held by the agency that may relate to or affect the safety or well-being of a child or young person. Now, you can envisage a situation where actually information which is strictly speaking health information about the parent might fall within that category. It might be relevant. What I would encourage people to do is when they receive a request like this is, if it's not obvious where it's connected, ask. Ask OT or whoever it may be, whether it's a constable or care protection coordinator, to explain that connection to you. Again, it's difficult to see situations where practitioners can get in trouble where they've not pushed back per se, but asked for information to satisfy themselves that there's a connection here between the parent's information and the purpose which is articulated in the Act. So if you can get that connection, get that information from them, it makes everything relatively straightforward, I think.
That's great. Well, we've covered quite a lot of ground today in this podcast. So if I can just sum it up, the learning points for today are that when the police request information, make sure you ask some very basic questions before making your decision to release or not. Unless there is a court order or production order, it is a discretion to release to the police. And there are some factors that you should be taking into consideration that you need to weigh up in order to arrive at your decision. And it's important to document your rationale for any decision that you make to release or withhold. That we can go to the police regarding information that we think that would be helpful to them. We can do that under Rule 11, which is discretionary. But there is no obligation for us to, say, report a crime. And when it comes to MSD, the Ministry of Social Development, or Oranga Tamariki, there is legislation that compels us to comply, and consent is not required. But to be certain about what the limits are of the information that you should be releasing. Have I missed anything out?
Yeah, I think that minimum release is a really important bit, that you only release the minimum information necessary to comply with the request, and to mitigate the risk, so that releasing all the notes, it's the easiest thing for the doctor often just to hit print, but actually it's not the right thing to do. And the other thing obviously is to ring your indemnifier, ring MPS if you've got any questions, because these things, they don't come up in your inbox that often, and then it's often a little bit of it's like, oh, what do I do with this? And it's always nice to ask, and that's what we're here for.
And it's exceedingly rare that there's real urgency with these requests, with perhaps the exception of the police and there's a missing person. But most of the time, yes, you do have that time to seek advice and make sure that what you're doing is appropriate.
That's great. So thank you, Lucy and Tim and Jo, again for just their contributions to this podcast. And thank you to our listeners for listening in today. I hope it's been very helpful, and we look forward to catching up with you in our next podcast. If you like the Medical Protection Podcast, please subscribe and leave a review. And if you'd like us to deliver a podcast on a specific topic, please email nzpodcasts@medicalprotection.org. We'll catch you next time.